us today. My name is Tim Chance. I am an attorney with Maryland Volunteer Lawyer Service and a member of CAN. It's my pleasure to introduce Kiernan Waters from Minnesota Lawyers Mutual today. So she's going to be talking with us today about some of the most common malpractice claims and what we can do to avoid them. Before we begin, though, I just want to go over some brief housekeeping. So this webinar will be recorded, so it will be accessible in the future for anyone who was unable to attend today live. During the actual presentation, participants are going to be muted, but if you have any questions, please enter them into the questions section or the chat section. I'll be monitoring both of those, and then I will forward those to Kiernan at the end to answer. And without any further ado, I'm going to hand off the mic to Kiernan. Thank you so much.
Well, thank you, Tim. It's a pleasure to be here today. I've been really looking forward to talking about these malpractice claims and what we're seeing, and especially the trends that we're seeing in the industry. So thank you so much for having me. For everyone who's joining us today, really a pleasure to be here. I hope you get some valuable information as a takeaway from this. I do want to just start with a little bit of a warning. I feel like in this, COVID era, everything going on, the news cycle is always so depressing. It's kind of the same with this presentation as well. In terms of the trends that we're seeing in this industry, which I'll be talking about, we're really concerned for what the pandemic and the fallout from the pandemic are going to mean for the malpractice claims. So if you're looking for, an optimistic outlook, I probably don't have that for you today, I'm sorry to say, but hopefully the information I share will keep your risk low and keep you from having any malpractice claims, no matter how you've been impacted by the pandemic and everything that's happened so far this year. So my name is Kiernan Waters. I am a graduate of the University of Baltimore School of Law. And after graduation, I went and worked as an estate planning attorney down in Annapolis. And I mention that because, one, that background was really important as I made this transition to working for Minnesota Lawyers Mutual Insurance Company as their regional sales director here in Maryland. But also because I know a lot of estate attorneys are probably tuning into this today because of their involvement in the CAN network, which is so great. So I will be focusing a little bit on what the estates trust probate world is seeing as well. And that's actually an area we're really interested in right now. Claims have been rising in that area of practice for a while, and we expect them to keep rising in that area because of a lot of factors. So I'll certainly touch on that. So great to have any estate planning attorneys, probate attorneys, anyone who kind of works in that area of law joining us today as well. Getting started, there are a lot of types of legal malpractice claims out there. And there are common malpractice hazards to all who practice, but depending on the different area of law, there are also certain things that come up more often than others. So the more you know, the better you can protect yourself, keep that risk low, and that's really important. From a malpractice insurance carrier, especially dealing with Maryland clients, we really want the malpractice claims to be low in the state. So we want everyone to be doing everything that they can, whether they're insured by us or not, because we have some aspects that we look at across the industry there. So certainly I want you to have a really risk-free practice, but hopefully you're running a risk-free practice as well, because a malpractice claim, even if it's unsubstantiated, and we do know that the majority of malpractice claims against attorneys are lacking merit, but you still have to defend yourself, and the time and the stress on top of everything else you're doing as an attorney, let's try to avoid that wherever possible. It's just not worth the headache. You have much better things, higher billable clients to be working on, billable hour requirements to be meeting. So best to keep those practices as tight as possible. And we'll certainly talk about how you can be doing that. Okay, so to get started here, just wanted to call out the difference between a malpractice claim and, a claim for professional discipline. So a violation of the rules of professional responsibility should not itself give rise to a cause of action against a lawyer, and they're not designed to be a basis for that civil liability. However, the rules of professional conduct do establish standards of conduct for lawyers, and so a violation of a rule may be evidence of a breach of the applicable standard of care. So they could be entwined, but really they're two separate things here. And legal malpractice occurs when an attorney breaches the requisite standard of care customary to the practice of law. Generally, a legal malpractice claim requires the plaintiff to prove that the attorney owed a duty of care to the plaintiff, that the attorney deviated from the applicable standard of care, that the plaintiff suffered damages, and that the damages were directly caused by the attorney's deviation deviation from that standard of care. So not all legal malpractice claims are created equal. Types of claims are varied across those different practice areas, as I'd mentioned. And when we're looking, really comparing the two, attorney discipline is going to include factors such as the nature of the misconduct, the cumulative weight of the disciplinary violations, the harm to the public and the legal profession, because that's really what those rules are serving, the public and the legal profession as a whole. Whereas the factors used in the attorney malpractice are the existence of that attorney-client relationship, the act constituting negligence or the breach of conduct, whether the attorney's acts were proximately caused by the plaintiff's damages or proximately caused the plaintiff damages, and the but-for of the attorney's conduct, would the plaintiff have been successful. So different things there, your malpractice claim versus your ethics board or your state bar are going to be handling those differently. So malpractice claims have been on the rise for quite a few years now, and there's a lot of reasons for that. And the pandemic has brought a whole slew of new reasons for why we expect malpractice claims to continue to rise in the future, but we have noticed that they've been rising for the past several years. Practice is becoming more complex, higher consumer expectations, expanding basis for liability, increased competition, failure of that lawyer-client relationship. When I talk to older lawyers, they're saying it's, the young whippersnappers out there don't know what they're doing, and that's a reason for the malpractice claims. On the other side of that, when I talk to younger attorneys, they're saying it's the old guys who aren't retiring and aren't as maybe familiar with the technology being used today, and that's the reason for malpractice claims. And really, there's so many reasons for malpractice claims. So it's just funny where those two sides come to head there. And actually, it's, when we look at the data, younger attorneys don't have as many claims against them because they haven't been practicing as long. Also probably because they're under the watchful eye of a senior attorney there. But we'll talk about where we do see these claims. So with the increased frequency of the legal malpractice claims, we're also seeing an increase in the severity of the claims, and that's determined by the monetary dollar amounts associated with a settlement or an indemnity payment. In 2019, all the major carriers had claims of over $500,000. Most of the carriers, over half of them, paid a claim of more than $50 million. One claim exceeded $100 million, and another claim exceeded $150 million in damages. So, not only are we seeing more claims coming about, but we're also seeing those claims being more expensive, and that's certainly a concern of ours as well. The one kind of silver lining there is that we are seeing claims being resolved much more quickly than in past years. And the way we had been looking at it was the longer the claim is open, the more expensive the claim tends to be. So if we can shorten that timeline of the claim, get it resolved quickly, we hopefully keep costs low. But with these rising indemnity and settlement payments, maybe that's going to be something that's going to be changing in the near future. So that's something we're looking towards. And then, of course, 2020 came along and everything changed. And we're not really sure how everything's changed just yet, but we certainly have cause for concern, as I mentioned at the start of this program. If the past is any indicator of the future, then the COVID-19 pandemic is going to result in an increased number of legal malpractice claims, just like in the aftermath of the 2008 Great Recession. Historically, economic pressures have always led to a greater number of claims against lawyers as clients look to, point the finger, give someone the blame, especially for commercial or other setbacks, whether they're warranted or not. Hard times, desperate measures, all that kind of stuff going on here. And so this is the slide that you're seeing now has some information from an Ames and Go study of the 2019 legal malpractice arena. And if you look there, saying the sustained shutdown of the U.S. economy this year due to the COVID-19 pandemic may trigger yet another wave of legal malpractice claims, similar to what we saw in the aftermath of 2008. So, even though we've noticed that claims in 2019 surged, looking forward a couple years down the line, 2019 may look like a walk in the park compared to what's going to be coming over the next few years. Certainly hard to predict, but a lot of the repercussions from this pandemic have yet to come, have yet to really be felt in some ways. And what we're dealing with here is really a 1-2 punch. Not only is the pandemic itself that's bringing dramatic changes to how you operate your practice, but the resulting economic fallout is also going to be having a lot of impact on where we see these claims coming in the future. So we're bracing for what's to come. We know those economic downturns produce an increase in claims. Certainly it's not hard to see how bankruptcy, foreclosures, labor, employment, intellectual property, those are all things that tend to ramp up when the economy ramps down. Failed deals in real estate and other business transactions often result in related malpractice claims. So, a lot of failed deals going on now, a lot of things that were supposed to happen, very changed because of the pandemic. Trust values are something impacted by the stock market volatility, and historically significant fluctuations in the value of trust assets have also resulted in claims against the lawyer, either the lawyer who did the work for the trustee or maybe the lawyer who was serving as the trustee in that case. So economic downturns also produce more fee disputes, and firms, struggle to maintain that cash flow. Clients are falling behind on bills, so now maybe you want to start suing your clients for fees, but that tends to result in a counterclaim for malpractice. And so, it's hard to be in an industry where sometimes you don't get paid for your work. I certainly understand that coming from private practice. It's not a great aspect of the profession here, but we always say, is it worth it to sue for fees if you're going to get sued for a malpractice claim as a result of that? Probably not. So some things to keep in mind there. Not a great outlook, but certainly a lot of steps that you can take to mitigate the risk of your practice, mitigate the risk of having a claim come against you. And so the AIMS and GO study, their top 4 areas of practice where they see the most claims were business transactions, corporate and securities work, real estate, and trust and estates work. And really, those are certainly like the top 3. Trust and estates is one that we've seen just really secure its place in the top 5 in recent years. So those are the top 4 from that AIMS and GO study from last year. At MLM, and I'll be focusing on the data that we've collected as an organization, Minnesota Lawyers Mutual Insurance Company. And just as a note, this type of insurance, professional liability insurance, is all that we do. So we're a monoline insurance company. We're also a mutual insurance company. And that's kind of why I mentioned we want the claims in Maryland to be low, because a part of our company, a part of our dividends go back to the state of Maryland and go back to all of our insureds. But if I can keep the claims in Maryland low, that's more money that's going to be going back to the insureds in Maryland at the end of the year in the way that we do our dividend. So, happy to be out here kind of giving these tips and tricks of the malpractice profession, how to keep those risks low for everyone, whether you're insured with us or not, because there's still a benefit to the overall profession in doing so. So just a little note on that there. But so the data, which I'll focus on for the next couple of slides from MLM, it mostly lines up with the data that we see from other studies and from the ABA itself. And what I'll be talking about a little bit later in the presentation is the most recent data. It just came out at the end of September, and that's from the quadrennial ABA study on malpractice claims. So kind of comparing that, making sure that MLM is seeing the same trends that we're seeing across the industry. As a company, we're a pretty small company. We're in about 14 states at the moment. So we just want to make sure that everything is lining up and what we're seeing is really what's going on across the nation as a whole. And I'll note where there are maybe some differences as well. So, legal malpractice claims can arise in many ways in the context of real estate transactions. That's our number 1 where we see the claim frequency at MLM. An error can be made in contract drafting. The client can lose a contract deposit. A client can lose the ability to purchase property. A client can lose a sale, can lose rental income. Title to a property can be lost. Liens may not be removed. Unknown easements can encumber the property. Property may not have had the required certificates of occupancy. And there's, any number of things that can go wrong in the context of real estate transactions that can result in a legal malpractice claim against an attorney. Not really a surprise there that it's, certainly one of the top claim areas for malpractice claims. Commercial real estate, part of real estate, of course, but they have an increased claim frequency due to the increased volumes of such transactions in recent years. Pre-pandemic probably. All this data is really pre-pandemic at the moment, but we have been seeing that increased frequency and because of the increased volume in commercial real estate transactions. And claims there typically involve errors in preparing the deeds, the mortgage, the financing document, and lease agreement, as well as inadequate management or maintenance of those escrow balances. So kind of a mix there between the drafting errors and that, escrow maintenance. And a lot of attorneys can get caught up with, escrow balances and also with their trust accounts. So that's always something that we're really careful of. Personal injury for plaintiff. Errors in representation in the context of a plaintiff's personal injury action can arise in many ways. Failure to sue the correct defendant, failure to properly oppose a summary judgment motion, failure to assert certain claims in the case, such as lost earnings or medical expenses, errors at trial, and even simple procedural errors that result in the dismissal of a client's action. The most common error that is made by attorneys in the context of handling a plaintiff's personal injury claim is probably the simple mistake of failing to timely commence the personal injury action within the applicable statute of limitations. And again, something that we're going to be watching now because of the pandemic with the tolling of the statute of limitations, that's going to create a little bit of havoc in terms of the calendaring systems, when those deadlines are, making sure everyone's still on the same page when all this is over, right? And then trust and estate. So jumping over family law, that's an emotional area of law. A lot goes on there. And I'll certainly talk more about it later, but not a big surprise for it to be highly ranked as, where we see a lot of claims coming from in that area of law. But trust and estate work, that accounts for a large volume of transactions in the US due to the sensitive nature of the work, and matters are susceptible to the client dissatisfaction. So again, another emotional kind of area of law we're seeing more and more. Demographic transitions have also been playing into the demand for trust and estate work, and we're seeing a massive transfer of wealth, the baby boomer generation, you see articles about getting your trust or getting your will done all over the news, AARP, and of course other magazines and newspapers as well. So it's kind of trending in and of itself. But with the baby boomer generation being so big, with the transfer of wealth at hand being so large, with people being litigious in general these days, that's where we're seeing a lot of the issues and why claims in this area have been increasing over the last couple of years. And we expect them to continue to increase as well. So trust claims tend to be costly to defend as well, and they have the potential to be really severe, especially if you're working with really, sophisticated, high dollar, high net worth clients. These claims have been seen as most worrisome for the small and the medium-sized firms. But legal malpractice claims arising from trust and estates work generally arise from the attorney's drafting of the estate planning document for the client, such as the will or the trust, right? Let's see, I'll touch on collection and bankruptcy here as we kind of round out these top claims or areas of practice where we see the most claims. And the number of claims that can arise out of an attorney practicing in the areas of collection and bankruptcy always been high. In recent years, though, there's been a steady increase in these number of claims brought against collection attorneys under the Federal Fair Debt Collection Practices Act. So I'll go into a little more detail there. Certainly not my area of expertise, but I do have a few slides where we'll discuss some of the details of the FDCPA in a couple of minutes. Prior to the pandemic, the growing US economy was fueling an overall increase in those business transaction matters, such as mergers and acquisitions, corporate securities, and failed deals tend to result in a malpractice claim. I already mentioned that, but it makes sense. It's pretty, stating the obvious, but that's what we see all the time. Claims in this area typically involve scrivener's errors in contracts, inadequate representation, breach of fiduciary duty, or a conflict of interest. And really, conflict of interest is a big one. I'll be talking more about that as well. These areas are also where we see the worst losses for large and mid-sized firms. And I think that just kind of makes sense too. You know, corporate business transactions, commercial law, mergers and acquisitions, those are things that are really going to be handled by a lot of the bigger law firms, just as a general rule. Whereas a lot of, you know, solo practitioner, smaller firms, they're the ones getting into the estate, trust, and probate work. So that's kind of why we see those claims in smaller firms versus in larger firms as well. Let's see, I just want to touch on some of the matters like transactional or real estate Ponzi schemes are what we're seeing more of these days. And they can draw a lot of firms into one claim, and that also produces a really high settlement. So when I mentioned, you know, the settlement payments or the indemnity payments that have reached over $50 million in the last year, it's probably because it involved just a whole bunch of different large law firms. And of course, when there's so many law firms involved, you know, good practices can kind of fall by the wayside. You know, who's really responsible for what, who's taking the lead, who's making sure to oversee that everything gets done throughout the different groups of people involved. You know, so that's where we see things break down in that kind of way. Okay. So here is, you know, I just touched on how we see different things at bigger firms versus smaller firms. Solo practitioners followed by small firms of 2 to 5 attorneys, those see the most claims against them. You know, there's probably a lot of reasons for why that is. Bigger firms have more resources available, more people to oversee and double check and review, whereas the small firms, maybe it's someone who is dabbling in an area of law that they're not so familiar with. Maybe they don't have that second pair of eyes to kind of check over everything. Maybe they don't have a paralegal to help get things calendared, whatever it may be. But you know, the solos just at 34% of where we see claim frequency compared to the smaller firms of 2 to 5 attorneys at 32%. But the majority of the claims do come from firms of under 5 attorneys. And here we see the claim frequency by activity type. So what is the main type of activity that leads to a claim? Really, it's human error. You know, you can't blame your computer or your cell phone for a malpractice action there, but you know, it's something along the line you failed to do, or you didn't do properly, or it didn't get done in the way that it should have. So it's really human error that's driving these claims. But you know, here is a better breakdown of exactly where we see the claim frequency by activity type. You know, preparation, filing, transmittal of documents, you know, it is a very broad category, so that is why it's probably the biggest category. Advice given, you know, also a broad category here. So, you know, another reason why it's making up 20% of the claims. But then also, you know, the ways that a contested proceeding starts, the pre-trial or pre-hearing activities involved, settlement and negotiation issues, the trial or the hearing, a title opinion, or some other investigation going on. Those are where we see the most claims. So the study doesn't include, you know, things that we see that are under 1% here, so that's kind of why it's rounded off, but that's the breakdown. We know that there's a lot of pressure on lawyers to generate new clients and more revenue and exceed the expectations of the clients that they're serving, but having risk management practices in place and using them. So not only having the practices, but being sure to go through them every single time, kind of a back to basics approach of making sure you're crossing all the T's, dotting all the I's, doing everything you need to do to mitigate your risk for a claim coming back to you. And those are the things that lawyers tend to overlook or rush through because they're trying to work on those billable hours. They want the high dollar. They don't want to be sitting there and making sure they run that conflict check every time. But it's those things, those kind of basic operations of a practice in those professional rules of professional conduct, making sure that you're following all of those, but also making sure you're documenting everything and that your client intake process is running smoothly. Those are the things that can keep your risk low. You know, partly this is an issue with law firm culture where there needs to be this balance between, you know, growing the practice, but also establishing a sustainable career. So, you know, you really want to try to find that middle ground that works for you. If you're, you know, too overwhelmed, if you're too busy, or if you're just, you know, spread too thin, that's where we start to see the cracks as well. And that's when you're more susceptible to a malpractice claim. So we can break down these claims a little bit more and see that administrative errors make up about 30% of the claims, whereas substantive errors make up about 45% of claims. And I'll talk about those substantive errors next. But here, in terms of the administrative errors, procrastination, lost files, lost documents, lost evidence, the failure to calendar properly, or the failure to react when you put that calendar notice in your calendar, but you haven't prepared adequately, or the deadline comes and it flies right by you and you haven't done anything. And also, of course, the clerical errors, the scrivener's errors, and the failure to document the file properly. A commonly alleged error is that an attorney missed the deadline. This is an error that can be preventable, but when it occurs, it creates a significant risk of liability depending on the circumstances. This is also maybe a basis for a claim going forward as parties continue to navigate COVID-19 closures, court deadlines, everything that COVID has done to, change the way that we had our calendar set up, the way that we had these court hearings scheduled. Certainly those dates have been rescheduled maybe multiple times at this point. So really important to be tracking those, making sure they get into your calendar and making sure you're aware of them. Also, COVID has changed the way that we use technology. And so that's going to be something that we're going to see more of in the future, making sure you stay abreast of the evolving orders of courts regarding closures, remote appearances, other developments, how you're using the technology in the court for a jury trial, or how, you're using technology with your clients as well. You're the one that's going to be responsible for the error. You're the one that's responsible to calendar properly. You're the one that's responsible to document your client files properly. So, don't let this get the best of you, even in these kind of crazy and chaotic times. Also, remember Model Rule 5.3, responsibilities regarding non-lawyer assistance, because it's all going to come back to you again. The lawyer shall be responsible for the conduct of a non-lawyer. That would be a violation of the rules of professional conduct if engaged in by the lawyer, if the lawyer orders or with the knowledge of the specific conduct ratifies the conduct involved, or the lawyer is a partner or has comparable managerial authority in the law firm in which the person is employed, has direct supervisory authority over the person, and knows that the conduct at the time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. So, especially when people have been working from home, you're not, going to a central office space, seeing people that water cooler talk, or, leaving the Post-it at someone's desk. Those are all things of the past. And so we're really worried about how attorneys have adapted to meet the needs of the current situation that we find ourselves in. And it's going to be concerning, and we'll see what happens there, how it goes. For some people, it's not going to go well. But if you're making sure you're on top of things, if you're making sure you're documenting, making sure you cross those T's, dot those I's, follow your processes, a very basic approach is really what's going to help mitigate your risk the most. If it just seems simple, or, oh, I don't need to do a conflict check because I know so-and-so, always better to go and just take the extra step, take that little bit of extra time to confirm everything, to get it in writing, to document it properly, because that's really going to save you in the end. So substantive errors, 45% of what we see. And again, failure to know the deadlines, apply the law, statutes of limitations, litigation deadlines here, dabbling in areas that maybe you shouldn't be dabbling in, complexity and specialized nature of certain cases, when maybe you should refer those to a more experienced attorney, or at least work with a more experienced attorney to make sure you know what you're doing, and conflicts of interests. So a few things going on here with the substantive errors, but conflicts of interest is really, it makes up a large portion of what other studies show. And at Minnesota Lawyers Mutual, we require a firm to use a conflicts check system. So that's probably why it's not a higher percentage of the errors that we see in our company. But if you look to other studies, like that Ames and Go study I mentioned at the beginning of this presentation, their 2019 study ranks conflicts of interest as the most cited legal malpractice error. So they're certainly watching that. Again, we just require the conflicts check. checked, so that's why we don't see as much of it in our neck of the woods. But the frequency of alleged conflict of interest cases is not surprising, as an attorney's duty of loyalty and breach of that duty is taken seriously by clients and the courts alike. The study didn't report if the firm failed to use a conflicts check system, or if the system, just wasn't adequate enough to result or to show the conflict. But it's always important to do that conflict check right away and not to skip over it. The 2017 Ames and Go study, so just from a few years ago, another study by Ames and Go reported that nearly half of conflicts of interest claims were rooted in lateral hires or merged attorneys not being properly trained or supervised. So if an attorney has worked consistently within one area of law over their career, or if they've continued to work for a former firm or maybe a former client, they really need to be properly screened, properly trained on how to do those potential conflicts checks. And any potential conflicts need to be resolved. It's not just enough to know that there's a conflict. No, it has to be resolved, of course, right? And so it requires nothing less than full disclosure, including the facts that create the conflict, how the conflict may adversely affect the client's interests, the ability to consult with independent counsel, and confirmed all this in writing. You can represent the client when you reasonably believe you will be able to provide competent and diligent representation to each affected client, and each client gives that consent in writing. So you can have a conflict of interest and continue to work with those people involved, but you have to do it in the proper way. So you have to be aware of it, they have to be notified, you have to go through that process to resolve that conflict of interest, getting it in writing, and then you can go on your way. But a lot of people overlook or blow through and don't take the time to do all that properly when there is a conflict at hand. And just since I've been kind of talking about client intake practices through these last couple of slides, I thought we'd take a little bit of a deeper dive there, just give you some practice pointers while we're at it. So best practices for client intake, things should be done, or in the box on the one screen, the blue box, things are best done if you can get them done in the client's handwriting, because then you can point it back and say, look, the client wrote this, the client gave me this information, right? So as much as you can get from them in writing, or, have them fill out during that intake process, certainly name, work, home addresses, phone numbers. But I think what's really important is the employment or business affiliations, and the employer subsidiaries, the parent corporations, officers and directors if involved, partners, shareholders, the identity of all friendly and adverse parties. Get all of that in writing. If the client can do it, then you have that to look back to, and that's going to provide you with some relief. And then for just client intake practices in general, when you're considering taking on a new client, you want to talk directly with that potential client. Don't leave that to somebody else's responsibility at the firm. Make some direct connection to make sure that you're going to vibe well with the client before taking them on. Once you have a potential client, obtain the necessary info to start that conflict check. This can start as a basic conflict check for now, but just run it through the system so you're aware of anything that could be coming. And then if there are no conflicts, go ahead and meet with the client, obtain more information, do another conflict check once you know what else is going on in the specific facts of the case, and you've reviewed the documents, and then once you have that information, you have a decision to make. Do you want to move forward with the client, or do you want to not engage with the client? And so, again, it's a back to basics approach here, which is the best way you can mitigate your risks. But if you stop after that initial meeting, send a short follow-up email or letter to the client and say, thanks, we haven't made a decision yet as to whether we're going to take on this matter or not, but I will follow up with you to let you know. Now you've made it clear that there's no attorney-client relationship just yet. Now you have the ability to either send a non-engagement agreement letter or an engagement agreement letter. And then that's going to memorialize all those details in writing for you. And that's what's really important, right? Let's see if I covered everything that I wanted to cover when I was just talking to you in my notes. Let's see, specifically when you decline the representation, that's going to be great to have in writing. You don't want to offer substantive analysis and conclusions regarding the merits of the matter when you're sending a non-engagement agreement. You just want to alert the client, or the non-client in this case, to the statute of limitations and any other time-sensitive dates. You don't want to attempt to absolutely calculate those dates and put those in writing unless you're really certain that there's an imminent deadline approaching. Otherwise, give them the general information, the general dates or statutes that they should be aware of for that type of matter. But don't get too specific there. That could come back to bite you, right? And also you want to, in a non-engagement agreement, you want to recommend consultation with another attorney. I don't recommend that you have a specific referral included in the non-engagement. Just say, you're more than welcome to go get a second opinion and, send them off on their way. Don't send it to a friend, or, maybe you're sending it to an enemy to handle. Just kind of be very general in those letters, right? Memorialize it, document it, but very generally. So you can see how some of these things do slow down the practice, taking the time to send another email when we know how many emails are going in and out of attorneys' mailboxes every day. So of course, having one more email to send, one more little follow-up, it can weigh on you, but you really want to do that, follow those procedures and those best practices. Okay, another area of law where we see, or another area where there's a lot of claims, is the area of intentional wrong. So it makes up about 10% of the claims that we see. And there's, fraud, malicious prosecution or abusive process, the violation of civil rights, and libel, slander, all kind of wrapped up under those intentional wrongs. A fraud claim asserted in the context of a legal malpractice action could be duplicative of the legal malpractice claim if the claim arises from the same facts and seeks the same damages as the malpractice claim. So we don't always see, we don't usually see a fraud claim without an accompanying malpractice claim. But it's possible that the fraud claim could be, or the malpractice claims could be subject to dismissal and the fraud claim not. So there are weird things that do come up when an attorney, intentionally engages in type of fraudulent activity there. Usually there are circumstances, or sometimes there are circumstances where the fraud alleged is separate and distinct from the facts that form the basis of the malpractice claim. Where the facts giving rise to the fraud claim are different from those that form the basis of the malpractice claim, then the fraud claim is distinct from the malpractice claim and is not subject to dismissal as being duplicative. There have been cases where the malpractice claim was dismissed, but the fraud claim survived. It's rare that there would be a fraud claim without that accompanying legal malpractice claim, because the alleged fraud is something that's not going to be covered under a professional liability policy. Generally we're going to focus on the malpractice-ish part that goes along with it. And even if there is an accompanying fraud case, we're still going to focus on the malpractice part of it, because your insurance carrier is not going to cover an intentional wrong, fraudulent activity by an attorney. So just be aware of that. Again, hard times, tight times in terms of what we're seeing these days, desperate acts, desperate measures. So following, the 2008 recession, we did see attorneys partake in more fraudulent activity, Ponzi scheme type of things, misuse of those trust funds. And that's, again, something we're bracing for coming up because of the pandemic and its fallout. Okay, so let's get into how we can not be hit with a malpractice claim, because I think that's what you really want to know, how we can evolve or get away from these. So for now, let's focus on business law. Certainly when business deal goes bad, clients want someone to blame, they want to point the finger, and they're going to point the finger at the person with the deepest pockets. So how can we not be subject to a malpractice claim if we're doing business law? Well, first of all, maintain that conflicts of interest database. And again, don't just maintain it, but use it every time, use it as soon as a client approaches you for representation. Reliance on memory alone is not a reliable or advisable strategy for determining whether a conflict exists. Regular use and proper maintenance of a good conflict checking system is imperative to avoiding a malpractice and ethics claim based on a conflict allegation. The conflicts of interest database should be regularly updated and searched every time a new client comes into the office. When new parties are brought into a matter, the database should be checked again. And not just new parties, I mean new clients, but new attorneys brought into the matter as well, of course, right? So have it, update it, use it, check it regularly, check it often. Identifying the client and memorializing the scope of the representation. So many malpractice claims stem from a lawyer's failure to clearly identify his or her client when handling a matter involving multiple parties, such as setting up a small business. Attorneys must be clear who they represent and adequately identify and memorialize the scope of that representation in writing, either in a letter or in a retainer agreement. Don't represent multiple parties. It's far too easy to say yes when a longtime client and his children, especially in the context of estate planning, right? Walk into your office and ask to prepare documents to transfer the family business or draft paperwork necessary to effectuate a real estate transaction from, father to son, whatever the case may be. It comes up all the time. But if the deal goes bad or the parties have a falling out, then they're bound to come back to the lawyer and claim that conflict of interest and representation for all involved in the party. So the best and safest course of action is to insist that each of the parties obtain separate counsel. And we are seeing, conflict of interest, rising claims in estates and trust. This is something to really be on the lookout for, especially when you're working with multiple parties, multiple people of one family. Avoid entering into business contracts with clients. I think this one's pretty obvious, but people still do this from time to time by entering into the business contract with a client. Keep in mind Rule 1.8 of the Model Rules of Professional Conduct gives fair warning to attorneys that get involved with clients in any capacity other than legal advisor as being dangerous. This includes activities such as investing in a client's business, accepting stock in lieu of fees, or making loans to clients. If the transaction goes bad, the lawyer's involvement will be carefully scrutinized, and the lawyer may end up facing an ethics or a malpractice claim by the client. So lawyers who dare enter into business deals with clients need to really follow the rules carefully. And number 5 here, be cautious when serving on client boards or any boards. I think attorneys are often asked to serve in this capacity, and there are some benefits to doing it. It also takes up some time and resources as well. But it's always a great line for your resume or CV, right? But be cautious when outside counsel becomes an officer director in a corporate client. The attorney's independence is going to be diminished. When asked to assume such a role, attorneys are advised to provide that full disclosure of any conflicts of interest, because of course that can come up here, and any potential loss of attorney-client privilege. If there isn't enough to discourage a client's request, then the lawyer should nonetheless consider declining the offer anyway, because it is risky. Many lawsuits are brought against officers and directors, and attorneys and their law firms run the risk of not being covered in most instances. So law firms should establish policies and procedures with respect to attorneys who are serving as officers, directors, or employees of any outside for-profit or not-for-profit business enterprise. And at a minimum, a firm should require the attorney to procure a directors and officers liability insurance. That's going to provide that extra coverage that you need when serving in that capacity, and possibly prohibit the attorney from providing legal services to that business enterprise to reduce that conflict of interest there. All right, next up, we'll talk about real estate. A lot of volatility in real estate in recent years. Foreclosures and refinancings were on the rise before the pandemic. Of course, foreclosures, bankruptcies, all this stuff is going to be impacted by the pandemic as well. But a lot of volatility in recent years. So a lot of volatility in the claims that we're seeing in this area of law as well. And so here, again, you want to make sure you avoid any conflicts of interest. One way that those conflicts come up in real estate transactions is where, the parties want the same thing and they want to streamline that process. So they only want to use and they only want to pay for one lawyer, right? So be careful. While joint representation of a buyer and a seller in a real estate transaction is not prohibited, there are instances when it is not permissible, and certainly it's not advised pretty much ever. Be sure you fully understand the relationships between and among the parties. Discuss the potential conflicts with them before agreeing to represent more than one party in any transaction. Remember that even when the parties agree on all the terms and simply need a lawyer to memorialize those and get them in writing, there still may be conflicts, and the lawyer cannot avoid malpractice liability by claiming that the lawyer was merely a scrivener of the deal. It's important that engagement letters make it clear you have agreed to do, that who you have agreed to represent, and who you don't represent as well. As always, be very careful when considering entering into business or real estate ventures with your clients. You also want to make sure for real estate work that you're supervising that non-attorney staff. While it makes sense to utilize non-lawyer staff, especially when you're dealing with the high volume of routine paperwork common in a real estate practice, think of the deeds here. A lot of attorneys use a form. Maybe their paralegal is using a form to fill out the deeds, but that is a place where risk can be involved. One red flag is if you have a poor non-lawyer staff to lawyer ratio. One attorney who's supervising 15 paralegals as they process these deeds or something like that. That's a place where that attorney is really not going to be able to provide the right supervision of those non-lawyer attorneys, and that's going to be on the attorney should a malpractice claim arise. ABA Model Rule 1.1 on competency and Rule 5.3 on lawyer supervision, make the lawyer responsible for the work done by the non-lawyer staff. So this means the lawyer should always review all work done by non-lawyers to ensure no mistakes are made. Even though some transactions are very similar to others, avoid routine and volume-based mistakes by being certain to adequately address each client's individual needs and communicate with the client. So, forms are great when you have routine work, but you got to make sure you don't rely on the form because that could produce a mistake. Every client is going to have their own individual needs and be a unique situation. So you want to make sure that there's that oversight to catch those minor differences and make sure that everything is according to plan. And with this type of real estate work, avoiding burnout. Again, high volume, high pace of work here, so you want to control that, because if things get out of whack too much, you get too stressed, you get too sleep deprived, those are, that's where there's a risk that you're off your game. And if you're off your game, you can make a mistake. And if you make a mistake, you could be subject to a malpractice claim. Oh my goodness. So time has flown by, so I'm going to move a little bit faster. I know I talk fast already, but hopefully you have the slides. So we can all, you can always refer back to here. Family law, the evaluation of those marital assets, what is a marital asset and what the valuation is, those are going to be really important, and that's something you want to make sure you don't make any mistakes with. Watching out for that second lawyer syndrome in family law, this references relying on a first attorney's work without independent assessment. So this can be really dangerous, as the current attorney will be held responsible for any mistakes or detriment to the client. Communication in family law, super important. Sometimes, your clients are pretty demanding about the communication going back and forth. So make sure you're sending those emails, following up those phone calls. It's an emotional, stressful time for them. So you kind of have to adapt to the needs of those clients to make sure there's no risk of a malpractice suit there. And again, suing for fees. I touched on that, so I'll keep moving on here. Personal injury, here we see people dabbling. It seems like maybe this great case walked into your office and you can't say no because it's such a clean-cut personal injury case. But if you're not familiar with really what's involved in a personal injury case, it is growing more and more specialized. You really need to make sure you're doing things the right way. We've talked about how important deadlines are. Also filing early so you have time to get everything done. Being really careful if you're working in another jurisdiction or working with an out-of-state party here, and making sure you're talking to your clients about taxes and medical lien payments that could be coming. They're not going to be familiar with that. You're going to need to really give them that information. Debt collection, you know what, for right now, because there's some other things I want to get to, I'm going to skip this. It's not my area of expertise. It gets a little, specific to the FDCPA here. So if this is where you practice, feel free to return to those slides at a later time. But for estates, trust, and probate, I want to make sure that, we're looking at what's going on in this area of law. So on the slide now is actually what the ABA Standing Committee on Lawyers' Professional Liability released in 2015 about how this is going to be a growing source of claims because of the transfer of wealth from the baby boomer generation, because of the amount of the wealth that's being transferred, and essentially the volume, value, and volatility make this a practice area that we really need to watch. So here, you want to make sure that you anticipate conflicts, you don't make any assumptions, you ask the hard, difficult questions that might make things a little uncomfortable, you're confirming mental capacity, you're documenting everything, and you're understanding privity laws of who can sue you, who might have a claim coming in the future, right? And now for the last couple of minutes, I just want to touch on what the new study from the American Bar Association's quadrennial claim shows, because this is pretty interesting, and the predictions for the future are, what has us concerned at the current time. So here, their top 5 areas of law: personal injury, family law, real estate, estate trust and probate, and collection and bankruptcy. It's the same top 5 that we see at MLM, but there's a little bit of a different ranking in those top 3. Notably, estates, trust, and probate, not only has it made its way into the top 5 across the board, but it's at number 4, and we're probably going to see it increase from there in the future as well. Over the past couple of decades here, you can see where these trends are showing. So if you look at the very bottom of this chart, you'll see that personal injury has been declining over the years, but family law and estate and trust work has been increasing over the last 2 decades. Claims by type of activity, very similar to what we see at MLM. This is just the results of the 2019 ABA study. Again, how the breakdown of administrative errors, substantive errors, and intentional wrongs, very similar to what we see at MLM again. Also very similar to what we see in terms of firm size, with those smaller firms of fewer than 5 attorneys, seeing the most claims. The silver lining, though, is that not all claims have any type of payment. So most of the claims that we see, over half of them, are abandoned without any payment or any settlement. So that's really good. And we take that to mean that those, 50% or so of claims lack merit. But some suits are dismissed for the defendant. There are settlement payments when a suit is filed, or maybe a settlement payment before a suit is filed. And a small percentage of cases do have a payment for the plaintiff. So the notable takeaways from the 2019 data is telling us that we're seeing more claims arise out of business transactions and also immigration matters. So as we've talked, business transactions, there's been an increased number of business transactions, and conflicts of interest, again, are at the heart of those claims. But immigration being up could be due to a number of factors, such as the changes to US policy recently, increased volume of matters and urgency, increased claims connected to loss of liberty, and potential dabbling in this area of practice by non-immigration attorneys are probably why we're seeing increases now. Settlement and negotiation claims are up 3%, making settlement now the 4th most common claim producing activity. This was pretty striking to the researchers involved in this study. Because settlement negotiation haven't been, a huge area where we've been concerned, but it seems like more people are going to settlement, more people are getting involved in negotiation claims, especially in family law, also in estate and trust work. So that's probably why we're seeing an increase there. And again, the claims for intentional wrongs by attorneys have increased. Desperate times, desperate measures, people can start to not follow the rules as closely as they should be. And what does this mean for the future? So, looking back to the data we collected following 2008, we are anticipating similar trends due to the current economic downfall and the volatility caused by COVID-19. Claims arising from advice given. Of course, hindsight is 2020, but hard times do result in more claims. And so we're expecting more claims in the future from the advice being given. Especially when you think about the advice being given now through employment and PPP loans and bankruptcy. So we'll see what comes of that. I already mentioned that we anticipate the intentional wrongs to increase. clients or lawyers who are going to be facing pressure to, kind of make ends meet now are really going to be struggling for a few reasons. They may start accepting clients that they wouldn't normally accept. That could result in a bad outcome. Dabbling in areas of practice that aren't their expertise, that they aren't familiar with, and again, suing to recover those unpaid legal fees. Those are all things that attorneys are really going to have to watch out for, apart from the intentional wrongs. But it's just going to be more difficult to be an attorney right now with all this going on. And then also, notably, the study showed significant percentage of increase in claims resulting from administrative errors. And I think, that's really because, well, the prediction now, it's been rising already, but the prediction now is that, well, what's going to happen when everything's changed because people had to move to work remotely, work from home, they're not in the same offices, they're not following the same procedures, they're not working with the same team in the same way because of COVID. So that what really has us concerned now as well. Lawyer mobility is also something that I think is going to result in these claims, because lawyers are going to be leaving practices, joining new practices throughout the pandemic, maybe starting their own practice for the first time. That's going to lead to more conflicts, maybe a lack of due diligence, and inherited claims as files get passed along, and maybe even insurance gaps between employments. So, those are certainly things to watch. And a little more fallout from COVID here just in the last couple of minutes. We are anticipating an increase in claims, of course, arising out of employment issues, the PPP loan program and the advice given in bankruptcies. We're hoping to not see scrutiny over pre-pandemic documents, but we are not expecting any special treatment from lawyers who fail to meet the required standard of care. And this is what I've been hearing and what the people who did the study have heard from people who are out in the field now, who have had hearings through the pandemic, and essentially the judges don't seem to have any sympathy for whatever might have gone wrong on the lawyer's behalf because of a pandemic related issue. There's a standard of care, you have to adapt and you have to rise to meet it, and you're not going to get special treatment in most cases just because, oh, you were working from home or you had to adopt new procedures because of the pandemic, or whatever kind of excuse there might be. So that's something to watch for. Right now in 2020, claims are low, but that's because they haven't been filed yet. So not only are we anticipating the normal claims to be filed soon, but we're also expecting a whole wave of pandemic-related claims to be filed. And we're expecting to deal with these issues caused by the pandemic for probably the next 5 years. So again, I don't mean to be negative or pessimistic here. This is, just the concerns that we see, and it's all rooted in the data. And again, those issues from working remotely, new court processes that were put into place through the pandemic, remote depositions going on, data security issues, new technologies such as GoToMeeting, Zoom, whatever it may be, as you're working from home, you have to rise and meet that standard. You have a duty under the rules of professional responsibility to maintain reasonable competence with relevant technologies, and that relevant technology and that reasonableness standard, that's a sliding scale. So you have to work with your clients to adapt to the technology that they use. You have to adapt to the technology that the court's going to be using now. And through all this, there's still concerns about attorney burnout and substance abuse, which there always are. We know that this is kind of a dangerous profession in some ways, but with the additional stress and the additional pressures of the pandemic, attorney burnout and substance abuse we're probably going to see a rise there, which is, of course, really worrisome. So I'll turn it back over to Tim to finish everything out now, but there are a few more slides here just so you have information. Here are, again, some more tips on how to avoid the top 10 most common malpractice and ethics mistakes that we see. So go back, take a look at the notes for this slide. I've mentioned dabbling a few times. Here's a little explanation of why we see dangers in doing dabbling across different areas of practice. And finally, if you make a mistake, you have to own up to it. You have to notify the client. You have to, best to inform them of the mistake in person, disclose all the facts, avoid giving legal advice regarding the potential claim, and notify your malpractice carrier as soon as possible so we can get to work in defending it. All right. So you have this PowerPoint. I hope you can go back and go into some of the details that I didn't have all the time for today. It's funny how these hour-long presentations just go by so fast. Thank you so much for joining us today, though. And Tim, did you want to take over and close us out?
All right, thank you so much, Karen. This was very informative, very helpful. While I go through, I guess, the last few slides, if anyone has any brief questions, you can put them in chat or the question section. We'll
And feel free to follow up with me, email, LinkedIn, whatever.
Great. And like Karen said, we have these slides available on the handout section. But if you're having an issue, I guess download those, just reach out to me and I can see directly. So just want to remind everyone to follow us on social media. That's Facebook, LinkedIn, Twitter, and YouTube. Let's go to the next one. Oh, could you? Thank you. Also, if you're looking for any pro bono cases, please check out our pro bono portal at mvslaw.org. In the top right, you'll see the section that says pro bono portal. You click on it, it'll look like that, and you can go through and select a case based on case type, county. So you'll find a case that fits what you're willing to do and what you're able to do. Go to the next one. I just want to alert everyone to some more upcoming training and volunteer opportunities. So on the 13th, next week, we have best practices for representing a non-filer. We have 2 webinars on the 15th with the legislative roundup, and then third-party custody, guardianship, and other legal strategies. And then we have on October 21st, the current state of utilities in Maryland. Just like this training is going to be recorded, we have other recorded trainings that are accessible at the linked website. Please check that out for more in-depth explanations of some substantive areas of law. And if you're not a volunteer, I just want to remind everyone to please sign up today. You can check out the volunteer application at this website here. And just lastly, I want to thank everyone for attending, and I want to thank Kiernan for being with us today to speak with us about this important topic and diving in. There was a lot to get through, but it was like, yeah, it was very helpful.
At the beginning, and then it just got to me. So,
I mean, that's how it is. Yeah, when you're in the groove, it goes. Right. So,
all right, well, thanks so much for having me.
Thank you, and thank everyone. Take care.